be private Instagram groups. It had to be a public group that anybody could see and be a part of.
And our employee handbook does say at page 45 that home or private accounts should not be used for student and family contact. So in those instances, when we would be asking a staff member for social media, I can conceive of a situation where we've heard from a parent or student that a staff member reached out on a social media platform to the student and here's what I've seen or here's what I know about. And we'd want to say, it's our understanding you've contacted our student. We'd like to see what information you've exchanged with the student who you have access to based on us employing you. Ms. Russell?
So I think one of the things that I have a concern about with regard to a policy, I guess, that would get into social media acceptable use or anything, I think that there's a free speech issue that we need to really be concerned about too. And just, coming from the public or the private sector, I just think that it's a very slippery slope in terms of being able to dictate what someone can and can't say. And I mean, even if it's critical of the organization, I don't think that I don't know. I just think it's a very slippery slope, and it would be very hard to put our arms around it. And I think with regard to the policy on contacting students, privately, messages, et cetera, it seems to me, Ms. Minson, that would fall under more of, and I don't know exactly which policy it is, but I guess just fraternization with students in general. And so that kind of falls into a different category than the acceptable use of social media with regard to what someone's broadcasting out to the public.
Yeah, and you also get into when there's communications with staff members using private accounts, if they're going to be communicating with parents or students on private accounts, even if it's nothing untoward, that could create a record under FOIA or FERPA that then we need to have access to so that we can provide it in response to a request. So there's a lot of reasons that I see there's a second place in our employee handbook under use of technology where the expectation is that staff utilize FCCPS accounts exclusively when corresponding via email with students and families regarding school issues, and that staff not utilize personal accounts as vehicles to communicate with students and with families.
Okay, thank you, Madam Chair. I'm really concerned about this policy. I'm just going to be really blunt about that. I understand there are plenty of reasons why it might be a really helpful thing to have access to that sort of information, especially if there is a concern about a threat to a student or inappropriate contact or something like that. And I get all of that entirely. I want to be really clear about that. But we're asking for access to something that could be completely private. I can think of lots of legitimate reasons why a person would have a social media account that they use privately to share information with family members only, for example.
Yes.
That I wouldn't want my employer to know about that sort of thing sometimes, right? I mean, there could be personal medical situations. There could be situations with circumstances related to family. Somebody is trying to have a family and can't. I mean, there's a whole host of things I could think of that are completely legitimate that I don't think anyone would want to have shared. So that really worries me. I also do understand, though, the argument that there are circumstances where having that information is really critical to be able to determine whether there's a threat, and I get that entirely. So I don't know how you find a balance between those two things, and I've spent most of the last several days struggling with how do you find a balance on this particular question, to be quite honest. There are some things that it could, and I know, and I will say, I recognize this model policy is more or less almost, but not quite, verbatim out of the Virginia Code.
Right.
There's one element of the Virginia Code that really isn't in here, and it gets to a point that Mr. Castillo made, so we can talk about that in a minute. But for instance, the first line says that the school board does not require current or prospective employees to disclose this information. And then it says, going further down, that in the next paragraph, the board would not be using the information to gain access if it inadvertently came through the network and, we got this. And then further down in line 16 and beyond, it doesn't prohibit the school board from requesting an employee to disclose, et cetera, if it's reasonably believed to be relevant, right? So I think the thing that I would actually be a lot more comfortable with is a policy that says the school board, I don't know if it's forbids or enjoins or what the right verb is, but says, no, you're not allowed to ask for it except in the following sorts of circumstances. I think that, to me, is more of a balance that I'd be more comfortable with. But I really am just speaking from my own personal perspective on this one. I can certainly think of things where we would say, yeah, no, the policy should allow folks to now be asked under a certain set of circumstances. It's just that I think the default setting ought to be, no, you're not allowed to ask, except if X.
Right.
And then I guess the other thing that might be a way of helping to solve a little bit of the discomfort I've got, I'm not sure that this really gets there, I'm just trying to think through this, is if it were not someone from the schools that was actually looking at the material. In legal cases that I know of, there have been situations where a private account is being accessed to understand some legal problem, and the court appointed somebody to be sort of the gatekeeper, an independent person who had the expertise necessary to say, well, yeah, that's not really personal, or yes, that really is. And only the things that mediator said should be accessible to whatever the prosecuting group was, those things went, but the other ones didn't. If there was some way to do something like that, that might be a way of dealing with a little bit of my discomfort. But I just have to say, I've really been wrestling with this one for the last few days, and it really worries me. So,
I certainly understand your concerns. I do think that the lines at 19 to 23 do severely limit the situations in which an employee's social media username and password could even be asked for. And it truly is when there's a formal investigation or related proceeding that there's been a violation of federal, state, or local law or the school board's written policy. So there's a narrow time when this could come up. In my estimation, the time that it would take to get an independent third party to get in to review it, often there would be spoliation. So we'd lose the opportunity to see what's there in the first place. So that would be my concern with putting that protection in place, or putting something that would require hiring someone to come in to do a review.
I guess to tack on to what Mr. Anderson had to say, reading through this policy, I guess I'm just trying to understand what the objective is, what we're trying to accomplish with it. And from what I can tell, it's just giving us the right to be able to get into somebody's social media account. And I guess I'm just trying to figure out when this policy would necessarily be relevant. I don't know, it seems like it's a little bit tricky to me in terms of what we're trying to accomplish with it.
So in my experience, there have been a number of times where we've had accusations of an employee engaged in predatory behavior, sexual predator behavior, that required an investigation. And we asked for their social media information, and when they gave it voluntarily, not in the city of Falls Church, and when they gave it voluntarily, what we found was there was a ton of grooming behavior that had happened previous to that experience that we were able to then determine that what had happened. And so that's the value of being able to ask for it, is that it helps us confirm in many cases when there's been really horrific behavior by a staff member. And in those circumstances, it was exceedingly helpful to be able to have that information.
I guess I'm just looking at this in terms of if the employee refuses, then what? I mean, so this policy obviously gives us the right to ask, but I guess I'm just wondering what would prevent us from asking, even if we didn't have a policy? And then on the flip side of that, what's preventing an employee from refusing other than saying there's I don't know, I'm trying to figure out the relevance of just having it in place in general, because if there's an investigation and if we have probable cause to be looking at these things, just like anything else, that we would, obviously the employee would say, yes, I'm going to provide you with the information, or no, I'm not. And that would dictate, where we would probably go from there.
So in this particular circumstance, we wouldn't need probable cause. We could leverage reasonable suspicion. So if we had a suspicion that something was going on, and there's an investigation of an employee going on, and we ask them for the information and they say no, that's certainly within their purview. Oftentimes in those moments, an employee will say, sure, here's the information, and it just is helpful in sort of either corroborating or not whatever the allegation could be. If they were to say no, and we had reasonable suspicion, we would refer it to Child Protective Services anyway, who then potentially could go out for a warrant and with the police, and then they could get a warrant, a search warrant, to get that information if they achieved probable cause, that standard for making the case. So it's just another, and I think the language that Ms. Minson said, it's an arrow in the quiver. It's just one more thing that we have an opportunity to ask for that helps us in an investigation of something absolutely tragic. And I think the scope of the timing and the actions that we would ask that information would be extremely narrow. So I don't know how to add language to it that would narrow it even more. But it does seem to me that if we think that there's a violation of state or federal law or school board policy, that should be sufficient for us to be able to have that authority to ask the question, can we have your social media? Can we have access to your social media? And the employee could certainly say no, and that's well within their rights.
Right, and I guess, what I'm just referring to is, even if we didn't have the policy, that would be within our rights because we're needing to protect our children. So I guess I'm playing the Phil role since he's not here, and just questioning, do we need a policy? Because these are all things, all actions that we would take, regardless of whether we had a policy in place, because that's our responsibility to protect our children. So I don't know. I'm not saying I disagree with the policy, but I'm just trying to, I guess, in my mind, understand if there's even a need for it. Because I think in some ways, as we've talked about before, policies can kind of tie our hands if they don't have the specific language or, phrase or whatever. But, with the absence of policy, I think that frees us up a little bit more.
It's an interesting question and a good point. I think the main reason that we would want a policy, at least from a school superintendent perspective, is if that investigation were to go sideways, I would want to be able to say, we had the school board's policy behind us that allowed us to ask that information. And being able to speak from that perspective puts us in a stronger position.
And in my experience advising other divisions before coming here, when this did come up, and a school board employee was asked for their social media password and said, well, that's private. This is the law in Virginia, so that school board had a policy that had this word for word that said, there is a formal investigation, we are allowed to ask you for that information. There's a school board policy that allows us to ask for that, and that did result in getting the password information. The other important piece I think that we haven't talked about is lines 21 to 23 that says that if the school board does exercise this right, if the school board does ask for the login and password, it's only used for the purpose of the formal investigation or the related proceeding. So not just can it only be asked for if there's a formal investigation or a believed